a lot of regulations govern or is applicable to this field of discuss this afternoon. So this is why, as a business owner, you should not just engage the service of any member or anybody in your business without looking at what the law says concerning that employment relationship, because where there is a breakdown of this relationship, what you fall back on is either your terms of engagement, the letter of employment that you've given to these people, or you refer back to the provisions of the law. And it is not always fair sometimes on the part of the business owner and also on the employer to rely on the provisions of the law, because the provisions of these employment laws, they are just general clauses, general terms that regulate employment relationship. So where you need to provide specific details, specific requirements, then it would be good to have a document that adequately fit into the scope of employment, the scope of engagement. And if you've been joining our series, this series, your business and the law of contracts, one thing that has been consistent is that I've been saying is that any agreements you are entering into or any document you are signing on your business, you should ensure that it is tailor made, like it is something that covers your business strictly, is strictly for your business. So you shouldn't just go out there to just copy sample contracts of employment online and just execute it between your staff or anyone you're engaging. But you should always ensure that any agreements you are executing between yourself, your business, and any third party, you should ensure that it is an agreement that is specifically designed for your business. So doing this, it will help you to position your business, it will help you to protect your business from any unforeseen event, because now you are the one dictating the tune. It's not just a general clause now, because the laws are already there providing these general clauses, but then you have the opportunity to expand on this general clause. You have the opportunity of limiting some of the provisions of the law to what you have agreed. I to give employees their payment of that this role is what your plan to govern working out. Back in is that is paying the owner is usually the employer, while the worker is referred to as employee. So in every employer, in every employment agreement, employment letter, employment contract, whichever term is being used, you would usually see the employer part and the employee. So the employer part, this is where you see the obligations of the employer, what the business of the employer is about, and the clauses that regulate, that concerns the employees. So you see their salary, you see their obligations, you see the term of contract, because there are some employment contracts that are just for a fixed time. It is not a full-time, even though a full-time employment, but it is not a long-term employment. Let me put it that way. It is full-time, but it is not a long-term employment. Some contracts of employment just allows you to work within a system, within a business environment, just for a limited period of time. So if standing or what you desire is that when you engage every business for, for just a month, a year, if the time, then you have an employment five time. So if you have and you your just say you plan them 3 months, employment letter, you've given the employment letter, this time frame is not stated, the employee is already assured of security of employment, job security, and person is happy, even if you are paying a very juicy amount of money, or irrespective of the salary that has been agreed between yourself and this person. So if the employee is already happy to say, oh, now I'm fully engaged in this particular enterprise, and the employee has already has this mindset of being in your employment for a long term, and just after the expiration of 3 months, you just tell the employee, oh, thank you for working with us, and you let the person know that it is time to quit, and the employee on the other side is like, no, this is not what we agreed. And cases like this, we've seen cases where people go to court for wrongful termination and unlawful termination of employment like that. So one of the ways you can avoid matters like this or issues like this is to have a clear document, clear that sets out the position of the employee. Every we can let them report, oh, in this organization, this is any level just who know what can in the duty exposed in like I said, as men matter is and the law are provide for basic that you have implement that, and if provide the labor employed to do this, and the labor court, or some employees have gone to court now go to court to seek for another to say that, oh, this person is my employer, person is not the employer, this is the person that is responsible for my insurance and all of that. So when you are giving out employment letter to people, ensure that this employment letter first is very clear on who the employer is, because if you are going to court, there is a position of the law that says that proper parties need to be in court. So if you, as an employee, you take someone who you think is your employer, is supposed employer, take the person to court, and at the end of the day, the court rules that, oh, proper parties are not before the court, then there's an issue already. There's an issue already, because the courts cannot decide on any matter where proper parties are not before it, and because any decision that the court is going to be given is going to be binding on the parties that are in court. So you see cases of people trying to excuse themselves from liability. So you need to start looking for who the employer is. So this is why once you receive your employment letter, so even though this series is basically designed for business owners, but then as an employee, to someone who is engaged in the service of someone, of a business owner, you work for a business owner, when you get your employment letter, ensure that this employment letter clearly spells out the name of the employer. Just last week I had to review an employment contract for someone, and one of the things I had to during the course of the review, one of the things I highlighted is the fact that the proposed employee should clarify the status of the employer, because I discovered that the name that was written on the employment letter was like a trademark, like their trade name. That was the name on the employment letter. The registered name of the employer was not written. You'll be able to provide adequate name for your employer. You need to be very clear regards the name of the employer. So if you have one employer, you have one and one person who is going to be responsible for this employee, let everything stated in the employment letter. Then the employment letter should also have the name and address of the employee. You don't engage someone you don't know, because the employment is going to bind both the employer and the employee. So another thing that you should have in your employment letter is the place of engagement. So if you have an establishment where you have a lot of branches, then when you are engaged with an employee, you should ensure that the employment letter states the place of assignment. Is the person going to be resuming in a part? So have it stated. If it's also an hybrid arrangement where the employee works remotely and also works on site too, these are things that you need to clearly state in the agreement, so that you avoid issues of, oh, I thought this arrangement is fully remote, or I thought this arrangement is an on-site arrangement. These are things that you need to clearly state in your employment letter. So if the contract is for a fixed term, like I said, we've seen cases where employers just engage the services of an employee within a fixed time frame, an agreed time frame. So you know that if the employee has to work just for 3 months, the employee's mind is already prepared for an exit from the business. So it is not a case of the third month you are telling the employee to exit the business and the employee is feeling that, oh, this is an unfair. We to take such, if it's based, the employer can start making arrangements of exit or also exit. So even if the long term relationship that techniques, when it's an offense, when the employee is contravening the employment contracts or provisions of the employee's contract, do you resolve it? Do you give notice the length of it? Because I have length of notice in the Labor Act. Like, the Labor Act is one of the principal legislation that regulates contract aside the other legislation. So Labor Act specifies the length of notice. We have 1 day, we have 2 weeks, we have a month, we have different provisions which relates to the length of notice to give to employees. So if an employee has worked for a time, there is a length of notice that you need to give before you terminate such employment. If the person has worked for a year, there's a length of notice. If the person has worked for 6 months, there's a length of notice. And if the person has worked for more than 1 year, these are things that you need to state in your contract of employment. And the fact that the Labor Act states that, oh, this is the length of notice. This is why you have the liberty as the employer during the course of drafting your employment contract to say that even though the Labour Act has stated that this is the length of notice, you can, the Labour Act has just suggested in the absence of in the absence of agreement between parties, so you can create your own term to say that, oh, this is the length of notice I want to give you. And once you have all of this signed, or once you have all of this clearly stated or spelled out in your in the terms of employment between the employee and your business, your organization, then parties are for their that employees to employers to their employees. Some employments, some employment demand that the employer, aside from the environment conducive computers and other facilities or working tools that the employers need to have a productive day at all. So if you be providing them all of these things, they should also be stated in the contract of employment. Then if you are providing them with all of these to then these tools, you should also have in that contract of employment the use of these tools you are handing over to them. So that give them are not ability. And this come for once visit them, have to go to your have to go uh, with the last of the them. Some they put accommodations. Some of them be think that uh, let's laptop iPhone like and that everything they oh my to the organization. If some of these tools you are handing over to them, if it's going to be for their sole use during the course of employment, then the contract of employment should clearly state that all the will be handing over the employment relationship. So is there another thing that you need to have in your contract of employment? Like I said, the Labor Act gives you the freedom. You have that opportunity to state all that you want in your contract of employment. So even though the Labor Act has highlighted some things that you need to have in your contract of employment, but then you should have anything that you feel that this is going to help my business, it is going to help us manage our employment relationship in the business, then you should have it. So these are special terms that pertains to your business, what you have in your own contract of employment. Someone who is in the fashion industry may not need to have that kind of clause in his or her contract of employment with employees in the business. So I believe that you've picked one or two things from what we've discussed this afternoon. If you have any question, you can drop it in the chat box. But remember that before you get employee business, you should have a start. And if you are listening to this broadcast and you've already engaged employees in your business without any contract of employment, or you have a contract of employment that does not cover the field, I would encourage you that you can review their terms of employment and still start on a clean slate. Just let them know that you are trying to regularize